Okay, today we have an awesome RETSY podcast for you. RETSY's real estate attorney, our main attorney, Michael Orcutt, is in the hot seat. He's going to share some amazing stories, what you need to be on the lookout for. He's going to give legal advice. I don't care if you're an agent, a seller, a buyer, you should tune into this one. And also at the end, we have a special bonus where he goes into what's happening now in today's real estate market with deed fraud. We've encountered it twice in this last week, so you need to tune in, protect yourself, protect your sellers, your buyers. It's going to be a great podcast today. I'm excited for you to learn more from the amazing Michael Orcutt.
Buyers notice a couple of white vans parked across the street. So they ask the seller, what's going on with that? Allegedly, the seller says, I don't know, maybe they're having a party. So I guess buyer kind of sloughs it off, close escrow. About a week later, the allegation is that the wife who is pregnant is unpacking in the garage, and some young person comes running across the street, screaming and demanding to use her cell phone. It turns out that's a sober living facility across the street where the white vans were, and it wasn't a party, even though the seller denies having made that statement. Those were the vehicles that were used to take, the occupants of the residents, to the grocery store and back or wherever. And so that turned into a lawsuit.
Welcome to the RETSY podcast. Today we're sitting down with RETSY's attorney, Michael Orcutt. Thank you for taking some time today, Michael. Of
course, glad to.
Appreciate it. I guess first I just want to start off by thanking you for your time over the last 5 years. I mean, we've had some really interesting, unique situations, and you've been the best resource for not only me as a broker, but for all of our agents, and we greatly appreciate that. And I know the agents greatly appreciate it. Every time you weigh in on an issue that just helps diffuse something and put it to bed, it's just invaluable.
We look at you as part of RETSY, not a part of your law firm. Michael and his wife, awesome wife, Jackie, we've known them for so many years. But I mean, to come to the Christmas party, it's like, I mean, you're, just as invited as any other agent. And the reason why I try to make sure that the agents understand who you are and why you're there is they always can chime in and like, oh, well, Michael gave the advice on this. Or Matthew has a situation he's got to diffuse and he brings you on the line. The relief you give to our clients and our agents, it's so critical. And I know I've said this before on other podcasts, but I've been with brokerages where it feels like the broker is just guessing, right? And then they call into a legal hotline and then they're kind of guessing with a little bit of an advantage. But when we bring you on a call and you diffuse a situation, it's just like, the client feels comfortable. And I mean, we're dealing with such high-end homes and specialty type of personalities, but you do such a great job with that. And then also bringing solutions to the table is what I love about what you bring to RETSY. So thank you.
Well, I appreciate that. And I'll tell you, I probably should kick up my malpractice insurance. When I started working with you, Matthew would talk about, so we've got an earnest money question. And I'm like, okay, let's talk about it. And by the way, how much is the deposit? Well, it's $500,000. Well, I better get this right. But no, it's good. I think we've had zero legal claims.
Yeah, zero.
Which is phenomenal.
Yeah.
That comes from good legal advice.
It comes from working in on the front end, right? Yeah. And not shooting from the hip.
Yeah. 100%. And not to say we've never had legal cases. We obviously were part of the Arizona class action lawsuit. Right. And again, your guidance and help on that. That was a scary time.
And the irony, the way that whole thing played out full circle. Do you remember that conversation we had? I was pacing in my front yard and you're talking me through this. It ended the exact way you said it was most likely going to end anyways. I'm like,
yep.
Yeah.
Yep. Yep, 100%.
Yeah, Matthew and I were talking about it, and here we are a couple years later, and it's, the world could have been fundamentally different for residential agents.
Oh, yeah.
I don't know that it's all that much different.
No, there's a couple extra forms. I mean, that's really kind of been the result, but
signing upfront disclosures. It did put a light on real estate agents, what they make, and what value they bring. And I mean, not to sound off, but I mean, sometimes agents aren't worth the commission that they're paid. Sometimes they're worth double it. It's just like at the end of the day, I kind of feel like it needed a little bit of a spotlight on it. Did I want to be that involved in it? No way.
Sure.
But we
Well,
did
it
lose
was an
some sleep.
opportunity too, right, for good agents to have the conversation. What are you worth and why are you worth it?
Yeah.
Yeah.
And you're right, some agents aren't worth it.
Yeah.
But a lot of agents certainly are.
That was before you guys became our stat agent.
Right.
Like I get served like 3 times a day. It was like a fun sport to go out to the mailbox and be like, I'm here, guys. Just constantly get all those letters. Scary time, but at the end of the day, like I wasn't overly concerned because our agents are the best of the best in the industry. I think you and I had this conversation. Like, if we have to take the gloves off and fight this ourselves, I'd rather fight it outside of the loop without those other brokerages, just because we have the best agents in the industry. But that said, luckily we didn't have to, and it did settle. NAR, like, God, I mean, they're hanging by a thread, but they got it settled. So.
Yeah, no, I mean, it's kind of more or less the same, but just additional disclosures, getting the buyer broker agreement up front, and
kind of feel like having Michael in the room. If I see something on this podcast I shouldn't be, like, you should just grab your water, and that'll be my signal to just
It's like a deposition. I'll kick you under the table.
Yeah, there we go. That works. But no, I guess everything's fair game today. So what do you want to start with?
Yeah. Well, Michael, would you mind sharing just a little bit of your background, and then we can get into some. I definitely want to talk broker horror stories. Like,
We can do that.
I would greatly appreciate that.
So I've been practicing, I guess it's since 2007 in Arizona. And the defense of real estate professionals, licensee or agents, brokers, that's been a significant portion of my practice since day one. And so over time, I've seen quite a bit. I've seen the good, I've seen the bad, I've seen the ugly, I've seen the horror stories. But I've also got a lot of, I'm happy to talk about some of the horror stories. I've also want to talk about some of the things I've learned, I think, that agents can take away from them.
That would be great.
And so when we talk about these things, it's funny to talk about, but it's what went wrong, what could have been done differently. A lot of our practice is talking to brokers, talking to agents, and saying, not how you defend a claim when you get sued, how do you prevent getting sued in the first place? And in some cases, that's unavoidable. And when I meet with an agent after they've been sued, oftentimes the first question is, I didn't do anything wrong, why am I here? And why am I talking to an attorney? The reality, unfortunately, is anybody can be sued at any time for anything.
Yeah.
You can do everything correctly, and you can still get sued. There's just some litigious people out there. And that happens in those cases, usually go out very, very quickly. But there's other times when agents do get things wrong, and those are the good teaching points. So 2007 to today, this practice has been a bulk of what I do. And it's been fun. It's always different.
Yeah.
And you and I have been working together for a number of years now. I don't think we've ever had the same conversation twice.
No.
Every day it's something new. And so that brings a lot of it's refreshing.
Well, and I mean, what's nice about that is, like, I have had similar situations come up again, and it's always great because then I can just refer back to, like, oh yeah, we dealt with that a year ago. This is how we resolved it. Here's the language that Michael approved for this transaction. Like, here, let's tweak it, and here we go. So that's been super helpful.
Good.
And I do feel like that's kind of my favorite part about RETSY is all of our agents are very experienced professionals. And so I don't get the silly when's my bins are due questions and different things like that a broker that has, hundreds or thousands of licensees that might be brand new probably gets. It's usually very unique, crazy circumstances.
Yeah, I've got a good in that regard working with you, but the stakes are high.
Yeah.
And that's the thing. When you're dealing in a $200,000 condo, it's a different question.
Yeah.
That you have to assess a little bit more carefully than when it's a $250,000 earnest money. You've got to be very precise.
100%. And I kind of forgot about that. It's typically when I do call you with an issue, that's your first question now is how much is the earnest money?
Right.
It's like, okay, it's 50 grand this time. It's 500 grand this time.
Yeah. I mean, the answer shouldn't be differently or should be different, but certainly if it's a large one, I'll put a little more thought into it.
Yeah. 100%.
Yeah. It's not just a matter of telling somebody they're right or wrong. It's like telling them that they're wrong, but here's why they're wrong and making sure that they understand it. So We see that across the board. I mean, we have another attorney we work with for like paperwork and setting up entities and all that stuff. And it's interesting listening to those calls when there's disputes or arguments on different things. And the way he presents his argument, to where I've seen other attorneys on the same call, like almost take the bait for it and agree with them. So, and then you just see them kind of roll into, okay, so you agree with me. Okay, so then what's the premise of this argument? You see it. But I mean, the reality is in real estate, if you have good bedside manner and you know what you're doing, you can usually diffuse any situation. I mean, the reality is a lot of agents, they're very passionate about their clients. They're passionate about what they do. When they get challenged, sometimes they take it personally. I always like to approach other agents that I'm working with in a deal of like, hey, we're a team to work together. You rep your client, I rep my client, but like our same goal is to make sure our clients are happy and the deal gets closed. And when you confront an agent with that, I mean, usually you have less like headbutts, but it's the agent you can't get a hold of. They have a team of 6. They never answer their call, this and that. And all of a sudden they just call you out of the blue and they're arguing something that's not true. That's when things escalate. Luckily for me, 25 years in the industry, I try not to let it. I just wait to hang up the phone and then tell my true thoughts to whoever's in the car.
Yeah.
But that said, it's just like you do a really good job of that. So.
Well, and that's Matthew and I talk about that a lot when there are disputes with agents from other brokerages. What can you do to diffuse the situation? I mean, the common goal between both sides is to close the transaction.
Yeah.
99% of the time.
Yep.
And there are times when agents' personalities and egos get in the way, and it's ramping it up is usually the worst way to handle a situation like that.
100%, yeah. I've had to have some tough conversations with agents as to, I understand you're upset at that buyer's agent, that seller's agent, whatever it is, but the next right thing, what's the next right thing we can do for the client? What is that step? Because that's what we're most interested in doing. There's plenty of time to file an ethics complaint over this grievance. You have 180 days, so let's worry about that after close of escrow. But what's the next right thing we need to do for the client?
Well, and it's important to keep in mind, too, that you're the agent. You're not the principal.
Yeah.
Right?
Yep.
You're a fiduciary duty, or you owe fiduciary duty to your client.
Yep, exactly.
So it's not about how many deals you've closed. It's about what you can do right now for your client, the principal.
100%.
It's so funny how agents can beat each other's throats and then the deal closes and everybody's patting themselves on the back and nobody's ever angry anymore and the ethics complaints go out the window and this and that. But I guess you see a lot. So
100%. Well, yeah, let's get into some of the stories because I caught a little flack from one of the fans of the RETSY podcast. One of our agents said that we didn't bring the goods on the Halloween episode.
Well, I think we had to edit out like 7 stories on the Halloween episode. But yeah, no, you got the goods. Like what? So imagine like our audience. I mean, you got to figure a lot of them are real estate agents, maybe some owner brokers, partners of ours in other states, and a lot of clientele. I mean, I met a gentleman the other day who was just like, oh yeah, I listen to the RETSY podcast. I'm like, awesome. What company do you work for? And it was like, a car dealership essentially. So.
Yeah, so these examples are cases that we've actually litigated. And the question is always going to be, who won? And unfortunately, we rarely get a who won other than the attorneys won because they got their fees, right? 99% or 98% of cases filed in Maricopa County ultimately are resolved before trial. And so I usually don't have – I can't say who won. I could perhaps give you my opinion. But a recent case we had, this settled within the last couple of years, and I think we're going to see more and more of this, and it raises a couple of kind of tricky disclosure issues. It was a property in North Scottsdale, a nice gated neighborhood. It was shortly before the close of escrow. Buyers were I think they were doing a final walkthrough. There are sellers there, listing agents there, everybody's there. Buyers notice a couple of white vans parked across the street. So they ask the seller, what's going on with that? Allegedly, the seller says, I don't know, maybe they're having a party. So I guess buyer kind of sloughs it off. Close escrow. About a week later, the allegation is that the wife who is pregnant is unpacking in the garage, and some young person comes running across the street, screaming and demanding to use her cell phone. Turns out that's a sober living facility across the street where the white vans were, and it wasn't a party, even though the seller denies having made that statement. Those were the vehicles that were used to take, the occupants of the residents, to the grocery store and back or wherever. And so that turned into a lawsuit. And interestingly, the plaintiff's expert admitted in his report that neither the sellers nor the listing agent were required to disclose the sober living facility. And that's because of fair housing laws. That is a protected class. You can't be liable for not disclosing it. The question becomes, if you're asked about it, what can you say? And so, that runs a continuum, right? On one side of the continuum is you could say something to the effect of, I'm not required by law to disclose that. The other side of the continuum is, kind of what was allegedly said in this case was, I don't know, maybe that's a catering van. The issue becomes, what exactly you say cannot be a misrepresentation, or it can lead to a claim. And so, again, the plaintiff's expert in that case acknowledged that there wasn't a disclosure obligation. In fact, you shouldn't disclose what it is. But when you're asked, you have to be
can't
truthful.
lie about it.
Exactly.
Yeah.
Yeah.
And the reason I start there is because there are a lot of those facilities throughout the valley, and they're not necessarily in lower income neighborhoods. Those facilities are throughout North Scottsdale, PV. So it's really how do you avoid that if you're the buyer? If it's not something you want to live next to.
Yeah.
It's a due diligence issue. It's visiting a neighborhood multiple times during the due diligence period, morning, evening, knocking on doors, talking to neighbors. The big takeaway from the seller's standpoint, or the listing agent for that matter, is if you're asked a hard question about that, it's always better to say I'm not able to disclose it than to be untruthful.
Yeah.
If you say I'm not able to disclose it, you cannot be liable for that. If, on the other hand, you say you don't know, and when in fact you do know, arguably that's a misrepresentation.
Yeah.
Yeah.
That's a tricky situation. Yeah, because
I wonder, is there a public database of those? Like, is that something somebody could research and find? I mean, I know we have that Real Reports tool we provide all of our agents, where it's just everything from the closest registered sex offender to the types of schools. I got to ask them and see if they have a database of that.
So the sex offender database, that's easy to search.
Yeah.
And I think that's on the Department of Real Estate's buyer advisory form.
It
I
is.
think
Well,
they link to that.
basically, if you take that advisory form, we found a tech partner that put all that data. So they do all the research for you. So the agent just has to type the address in, hit submit, and then everything's there.
And
permit
sober
history,
living,
you name it.
The sober living facilities, at one point there was a public database. I don't know that exists anymore. And once you start wading into fair housing laws, that can be an issue as well.
Yeah.
So I don't know. That's something we could certainly look into.
But I feel like that's something people would want to know.
Yeah. No. And
Especially if you're spending a certain price point in a certain neighborhood and this and that, it's it'd be good to know. I mean, I know the two in Arcadia proper. A lot of people don't even know about them, but there's two. So, that said, it's yeah, I guess that comes with working with a more experienced agent than not a more experienced agent.
Well, yeah, and that's geographic competency, right?
Yeah.
So if you work with an agent that only works or works in a confined area, they're going to know the neighborhood, and they're going to be able to have those conversations with their clients.
yeah.
Absolutely.
Well, and I think too, is the best advice for the buyer there is you need to visit the neighborhood multiple times, multiple different times a day, and knock doors. Get to know the neighbors. And
What was the ending to that? I know nobody wins, but the attorneys. But
It's settled like almost all cases do.
Seller gave the buyer some money.
Correct. And so, but certainly, I don't think the buyer would say they won. The seller didn't win. They had to pay quite a bit of money to get out of it.
Yeah.
And so, that's the takeaway there is, you have to be truthful.
Yeah.
And it's better to disclose or be truthful about what than it is to roll the dice. And I think that's a common thread you see a lot of our cases is if you don't make the disclosure. In this case, it's different, right? Just to be clear, the sober living facility, you're not supposed to disclose that. Yeah. So if asked, you say, I'm not required by law to disclose it. Other situations we'll talk about disclosure obligations, we find that if the disclosure is made, there's still a pretty high likelihood the buyer will go forward with the transaction because it's just maybe it's not that material to them. But if the disclosure is not made and the buyer finds out after the fact, they have the benefit of hindsight, right? They can say, I didn't know it then. Had I known it then, it would have been extremely material and I wouldn't have purchased the property.
Yeah.
So another case we had, this was a property line encroachment. There's a property in Arcadia. And this delves into a couple of issues we've talked about frequently. So this was an estate sale. So the children were selling on behalf of a deceased parent. They had very little knowledge about the property. So the hire listing agent, she puts it on the market, gets an offer. During that first buyer's due diligence, they find a garage encroachment. So basically, at some point, somebody built a garage for this property over the property line, which obviously is a pretty significant issue. So buyer number one, they find that out, they cancel. They write a BINSR, we're canceling because of a garage property line encroachment. Listing agent goes back to her clients, the children, and says, hey, tough news, buyer number one cancels. Don't worry, we'll get it back on the market. We'll find another buyer. Listing agent doesn't provide that BINSR to those sellers, right? So as far as they know, it just canceled. Buyer number two comes along, goes under contract. Their inspector doesn't find the encroachment, and they don't find it until after they close escrow. And that's a situation where it's almost an indefensible lawsuit, right? Because
That's the realtor.
it's the realtor.
Seller never knew.
In a lot of our cases, we have pretty strong defenses when we're representing a listing agent, right? In Arizona, essentially the standard is the buyer has to prove that the listing agent had actual knowledge of an undisclosed latent defect. And so if if I take a listing, I may not know a whole lot about the property. I'm relying in large part on what the seller discloses. But as long as I don't know, I'm not going to tear through the property to try to find mold hidden in a wall cavity.
Sure.
And so if ultimately the buyer does find mold after the close of escrow, their liability case against me as the listing agent is predicated on proving that I had knowledge of it. And that's usually, it can be a very difficult task. In the other hand here, that first BINSR is going to be disclosed as part of the lawsuit.
Yeah.
And when that happens, the buyer has actual knowledge, admissible evidence that the listing agent had knowledge of a serious defect that wasn't disclosed.
Yeah.
And so, again, cases like that settle, but they settle for a whole lot more. And those are the types of cases that really affect your insurance premiums going forward. So I'll turn that over to you. Let's talk about what happens when you get a BINSR cancellation.
Yeah, I mean, the listing agent really kind of ran afoul by not providing that to our client. I mean, that immediate conversation should be, hey, this is a big issue. The buyer canceled because of this reason. We need to remedy that issue, or we need to, if not, it absolutely must be disclosed to future buyers.
And let's be clear, this was not a RETSY agent.
This
right?
was not. This was not a RETSY.
Yeah.
This one
I don't
goes
think
back a
anybody
few
in our
years.
company would ever do that.
No. But
I mean, you'd think also as a seller, though, I'd be like, why?
yeah, because
I mean, that's the number one question. Like,
Yeah.
they ask it even before you tell them.
yeah,
They're backing out. Why? It's like,
they didn't like X, Y, or Z, or found X, Y, Z on the inspection report, or
Yeah, in that case, discovery didn't get that far, and we didn't depose the sellers, and I don't know what conversations happened, right?
yeah,
But the other thing we'll see in litigation is there's a lot of he said, she said disputes.
sure,
In with any of these types of risk reduction talks,
Yeah.
I'm often asked the question, what can you tell agents? If there's one thing that you can tell agents to reduce their potential liability, what is that? It's get things in writing. Verbal conversations in litigation, if there is a certainty in litigation, it's that verbal discussions never happened.
Yeah.
Verbal disclosures did not happen. So if the listing agent in that case actually had told one of the sellers that, hey, the buyer canceled because of this, in litigation, the seller is going to say, that conversation never happened. I don't recall her telling me why.
Yeah.
And because if she told me, I would have told her to disclose it. So the seller would disclose it, the seller would take the position in litigation that conversation never happened. And so a verbal disclosure is essentially worthless.
yeah,
In litigation. So what needed to happen there is the listing agent needed to provide the BINSR to the sellers.
yeah,
email it to them, and in the email itself say, hey, sellers, this is why the buyer's canceling. This is a serious issue that, to your point, either needs to be remedied, right, or we need to make full disclosure. But we've got to make that decision before we proceed.
Yep. Before you put it back on the market. And
Is there a certain period of time if the garage had been there for over, was it 6 or 7 years, that's like adverse possession?
So
Easement by adverse possession or something like that? Or
you could get adverse possession. It's a 10-year period in Arizona.
Okay.
But there's still disclosure obligations, right?
Of course,
because
yeah.
adverse possession can effectively change title, can adjust a lot line around the garage encroachment, but it takes legal action to perfect it. And so essentially the buyer, if the buyer could establish that the garage had been over the lot line for more than 10 years, the buyer may be able to keep the garage and not have to move it and have a slightly larger lot size, but they're essentially buying their way into a lawsuit, right? So then they're going to have to go sue the neighbor and go through what could be a multi-year and very expensive lawsuit.
Yeah.
And so, even if you have adverse possession, that still needs to be disclosed so that the buyer can understand what it is that they're getting into.
No, 100%. Yeah, I'm glad that wasn't a RETSY deal.
Yeah. But when you're talking Arcadia, it's like the lot lines are just so off on just about every house. Like I remember we did an addition onto our house on the south side, and luckily my builder, he's like, hey, it's worth it for you to get the survey, get the pins marked, mark where the property thing needs to go, because anytime you're coming up on the 10-foot setback, like, we were like 11 foot, so we're fine. But he's like, anytime that close, it's just better to get that done. And then like come to find out, like my whole neighbor's fence is like 3 feet into my property and this and that. But it allowed me to build what I needed to build where I needed to build it. But that said, it's like, okay, I only had him survey the south side. I was scared to survey the north side.
You probably picked it up on the other side. That happens all the time. Lot line discrepancies we see a lot. Where, and oftentimes it's when the subdivision's platted that the plat might be right, but the fencing contractor 40, 50, 60 years ago wasn't careful enough and put a fence a couple feet onto the lot line.
And then that just
and sometimes it carries through.
Yeah.
So you get your same square footage. Other times it doesn't. But it can be a very serious issue when it comes to setbacks and additions.
Yeah, no, especially in that area, we wanted to get it surveyed, and we're right on the border of the Arcadia floodplain. So, wanted to make sure that I was 100% out and all that stuff. But, we joke because my neighbor's house to the south, it's 3 feet lower than ours, and they are in the floodplain. I just kind of joke, if that big one ever comes, I'll throw you a life preserver or whatever. We've never seen I shouldn't say that. Redonda sees a lot of water. Mm-hmm. Okay, how's this for disclosure thing? If you're driving down Redonda between 44th and call it 46, and you've been through one of those rainstorms where you see the water going to the front door, and you list the house, and the seller's like, no, we never have flooding issues here. And it's like...
So if you're a listing agent, you have personal knowledge of it, you absolutely have to disclose it.
You have to disclose it,
and
right?
that's clear in the administrative code.
Yeah.
And I think, it's a balancing act there, right? Because you have an affirmative obligation as the listing agent to disclose a known defect. If you've seen water flood into the front door, you have to disclose it. Yeah. How do you balance that though with the fiduciary duty to the client? And I think the answer there is you don't list the property. Yeah. You have the discussion and you say, look,
I showed her the photo.
Even better.
I'm like, well, it wasn't flooding your house, but it was a half inch from the threshold of your front door, and all you could see was water from Redonda to your front door.
And the discussion with the seller is, look, I'm not the only one that has this photo. I'm not the only one that's seen it. All your neighbors
know about this. You're not hiding anything.
You're not hiding anything. And we disclose it, and we'll still get the house sold. If you don't disclose it, and that gets back to when is something material, right? If you don't disclose that, and the buyer's going to find out after the fact at some point, and when they find out, it is the most singular material thing that the buyer could have ever discovered in their minds.
Yeah, exactly.
Whereas had they known it during the inspection period, gives them the opportunity to consider it, right? They can talk to experts. They can say, well, that was a 500-year rain event. It's unlikely that would happen again, and here's steps I can take to mitigate. Mm-hmm. Maybe berming, could, at a very reasonable cost, prevent that from happening again. And so you see buyers work through those issues. There's probably 20 different things a buyer looks at in terms of what's material. Location, amenities, square footage, bedroom, bathroom count. And you can sell a house with a disclosed defect, because the buyer may say, this checks all the boxes for me. There's an issue here, but I can probably work around that issue. But if you don't make the disclosure and they find out afterwards, then they're going to say, with the benefit of hindsight, that was the number one most important thing to me, was if I would have known that the house had a flood incident, I never would have bought it.
Yeah.
And they get the benefit of saying that.
Yeah.
And so, when in doubt, disclose. That's the answer.
Even in slight over-disclosure is better than not, I know with our team, it's like my team kind of runs on autopilot sometimes when the transaction's already in place, but we had one recently where there was like a toilet O-ring that was leaking upstairs and you could see drywall damage, and the seller's like, well, it's just an O-ring. And it's like, well, you still have to disclose it, especially during the listing period. And we made them do the paperwork, and it was a little bit of a battle. I actually had to get on that call myself and just explain to them, like, you have to disclose it. Like, it's a roof leak. It's a leak from the toilet in the second story roof. So, it's interesting though, but this goes back to working with an experienced agent that is there to protect them. So,
yeah, and it's for the seller's benefit, right? In that situation with a minor leak, it's probably not going to deter a serious buyer from going forward. They'll investigate, they'll find out what it was, and they'll most likely move forward. But if you don't have that serious conversation with the seller and the disclosure is not made, that's when it ends up in litigation.
Yeah.
I think it's gotten better over the years. I mean, I can remember back in the 2003, 2004 days where it's just like you go into a house in Glendale and it's like a gaping hole in the garage, and you call the agent and we're like, what happened here? And he's like reading the spuds. He's like, I don't have anything. Like, what are you talking about? I'm like, it's like a drywall hole the size of a Volkswagen in the garage. Like, what do you mean? What happened here? Like, you could see the trusses. And, the reality is like back in the day, it was just like they would submit that, sellers would sign, everybody would know about it, but it wouldn't be on paper. And I think it's gotten a lot better.
Yeah.
Or maybe that's our standards have moved up a lot. So.
Yeah. I can think of one case we had at RETSY. This is resolved, but we had that seller that didn't want to disclose some septic repairs. And our agent didn't get the spuds prior to the property being under contract. The seller filled them out, got them to us a day or two after opening escrow. And then upon reviewing, saw like he made no mention of the septic repairs. And she pointed it out because she actually allowed the septic company access to do you remember this one?
I do.
Access to the property. And it ultimately came down to our agent telling the seller, like, look, if you don't make the disclosure, I have to. Like, I'm legally obligated to, because I know those repairs happened. I allowed them access because he was out of town or whatever the situation was.
And at the end of the day, if you're the seller, you're not going to get away with it. There's a paper trail there.
100%.
Right? There's neighbors, there's Ring cameras, there's everything's there.
Yep.
So.
Yep. The buyer is going to find out at some point. And when they find out, they're going to be very upset about it. And rightfully so in all of these situations. We had another case. This was an owner-agent case. And why that's important, I'll talk about in just a minute. But owner-agent lists the property, goes under contract with buyer number one. Buyer number one does a pretty comprehensive inspection of the drain lines, which I'll say as a sidebar, if there's point number one for avoiding liability and exposure as an agent is documenting everything in writing. Don't rely on verbal disclosure. Point number two is get sewer line scopes, right? If you're representing the buyer, do it in all cases. At a minimum, send your buyer client an email saying, I strongly recommend that you pay for a sewer line scope. I've got other agents that I work with that, as a matter of course, they will pay for it because they know the importance. And it's not just North Central Arcadia houses or Mesa houses with 60-year-old sewer lines. New builds can be affected, right?
Yeah.
Where your contractors are dumping trash down.
Yeah. Or they could have a belly in a month because it wasn't properly compacted or something.
Right, and so it's not necessarily the age of the system.
Yeah.
And the sewer line scopes are inexpensive. So in our owner-agent case, buyer number one gets the sewer line scope. It comes back that it's in bad shape, right? This was a ranch-style home built in probably the early 70s. So we're give or take 50 years old at that point for the sewer lines. Has a discussion with the owner-agent. Owner-agent agrees to make some repairs, but not what the buyer's experts were recommending. They recommended they basically said you need to redo the entire lines under the slab and then all the way out to the street. Like the system is failing. The owner agent ultimately did something less than that, which was a lining of a certain section where they'll kind of chip out around a couple of drains and then line one section. So buyer, they disagree about the scope of repairs that the seller is willing to undertake. And so buyer number one cancels. Owner agent goes ahead and has that scope of work done, right, the lining project, but then puts it back on the market, does not disclose that there are any sewer line issues.
Or repairs.
So buyer number two goes under contract. They don't do the sewer line scope. They close escrow. Buyer number one apparently has a hunch that there may not be disclosure in this case. So buyer number one tracks down the contact information for buyer number two, calls buyer number two and says, I see you just bought this house. Congratulations. By the way, did the seller tell you about what my inspector found? And did he do all the work? That turned into a very, very nasty lawsuit that lasted a very, very long time. And that
owner agent, E&O doesn't cover you on owner agency for agents.
There can be limited coverage issues. Errors and omissions insurance typically covers negligence-based claims, right? And so, an example of that would be I had a duty to, advise my client of something and I allegedly didn't do that. That could be negligence. That would be within the scope of coverage of E&O insurance. What E&O insurance won't cover are contract-based claims. And so if the buyer sues the owner agent in the capacity as an owner, that's a contract-based lawsuit. And so there were huge coverage limitations. And so it's an absolute mess. And the takeaway there, well, there are multiple takeaways, right? Sewer line scope, we
do it on every property.
Yeah.
It used to be like the inspector found an issue and then you got a sewer line scope, but now it's part of the, hey, here are your 3 costs.
Sewer line scope, if buyer number one cancels, provide that Binzer to the second buyer. You don't have to give them the actual form, but you sure as heck should update the SPUDs to reflect exactly what's on there. And we can talk about home inspection reports and how that plays into it as well. But then owner agent, right? I mentioned before, one of the defenses we have in a typical lawsuit against a listing agent is I didn't have knowledge of the alleged defect as the agent, and I didn't have a duty under Arizona law to discover it. And that's true. When I take a listing, I don't have to go around, I don't have to crawl up in the attic to try to see if there's evidence of moisture intrusion. I don't have to sniff around for mold. If there are red flags, that's a different story, but I don't have a duty to investigate. When I'm an owner agent, that defense falls away. I've lived in that house for a certain period of time. If it rains and it leaks, I know about it, right? And so I don't even have to investigate. I know what's wrong with my house, right? And so over the course of ownership, you're going to find a bunch of little ticky-tack things that should make their way under the SPUDs. And so you've got to be extra careful if you're selling your own property as a real estate licensee to make sure every single thing that during your entire period of ownership is disclosed. Because if it's not and you get sued, you're going to be paying for a lot of the fees and costs and potentially a lot of the settlement dollars yourself.
Yeah.
Those listening in that aren't in our industry, SPUDs are seller property disclosure statements. Basically, it asks you everything from like, can you hear airplanes to have you ever had sewer issues, electrical issues, what permits on the house, did you use a contractor, what their information is. It's kind of like a full doctor checkup on every single house that you should thoroughly review, not just rely on your agent to review it for you. So.
Well, and yeah, so how did that shake out for the owner agent? Can you share was there a Department of Real Estate complaint or did it end in court or?
I don't believe there was a Department of Real Estate complaint in that case. The department, that's the type of case that the department would have taken a very close look at.
Yeah, I imagine they would.
That case, it was ultimately resolved. To put it in a word, it didn't, or several words, it didn't work out well for the owner agent.
Yeah.
In a situation like that, the typical defense case that we represent real estate agents on, they may be liable for a deductible, and then their errors and omissions carrier picks up the defense beyond that. But when you have these types of coverage limitations, when you're an owner agent, there's going to be significant shortfalls. And the insurance carrier is likely going to say, we'll cover what you did wearing this hat, but not what you did wearing this hat.
Yeah.
And oftentimes that may mean if we're going to settle for $100,000, we, the carrier, will pay $50,000. You, the agent, are paying $50,000 out of your own pocket, above and beyond whatever deductible obligation exists.
Yeah.
Yeah.
Yeah. That
Hopefully people are taking notes right now that are real estate agents. Disclosure. Over-disclose.
Well, I have shared that. So you told me that story a few years ago, and I've shared it with a few agents when similar situations come up, and usually it under the context of buyer got a quote from XYZ contractor, roofer, HVAC, plumber, whatever. This was their scope of work. Seller wants to remedy it. Got a quote from this contractor. They disagree about the scope of work. And, really the advice you'd given me that I've been passing along is to get a third opinion, and really kind of from there move forward with what needs to be done and disclose it all. Provide a new buyer, if that first buyer canceled, provide the new buyer like, hey, here's what was found. Here's the 3 quotes we got. Here's what we did.
Right.
And essentially, as long as you disclosed everything, then I don't see as much liability there.
That's exactly right. And you don't necessarily have to go with the high bid. In many cases, you won't.
Sure.
But yeah, disclose everything,
Yeah.
right? Disclose all 3 invoices and explain why it is that you picked this one.
Yeah.
And that gives the buyer an opportunity to say, okay, well, yeah, that was a reasonable decision.
Sure. And during our inspection period, we can take a closer look at, was that the correct remedy?
And then, the buyer can also then prepare for their period of ownership. They can say, okay, well, they did this. Maybe something else is required, and we can budget for that, right?
Yeah.
Mm-hmm.
And maybe we can even negotiate for that.
Yeah.
And we can say, well, we would have paid X for the property. Now we'll pay X minus $5,000.
Yeah.
But if that happens and it's negotiated successfully, then there's no liability, right? The disclosure has been made. The buyer has consciously made the decision to proceed.
Exactly.
And that's how you insulate yourself. And this doesn't just apply to listing agents. This applies to sellers. And a lot of what we're talking about is, the listing agent's protecting the sellers.
Yeah.
Right? Because your seller that doesn't want to disclose septic repairs, to your point, Chris, people have ring cams. We can find out who did the repairs. We can subpoena that company. We can get all the information we need to prove that you had knowledge of it.
Yeah.
And at the end of the day, if you make the disclosure, the odds are very, very good that the buyer is still going to go forward with the property.
Yeah. Yeah.
Yeah.
It's just hard to convince the seller in the moment because they're wanting to keep the deal together. They're wanting to move on with their life and whatever their plans are after this home closes and don't want to do anything to jeopardize it. But, at the end of the day, you're way better off disclosing it. And even if the buyer cancels, they cancel, great, move on and not have a potential lawsuit hanging over your head for who knows how long. Is it 6 years? Or is there a statute of limitations on a non-disclosure?
It depends on the claim, but if it's a buyer suing a seller, it's typically a breach of contract claim, and that would be a 6-year statute of limitations.
Yeah.
And that doesn't necessarily start at the close of escrow. It's what we have is called the discovery rule, which means the 6-year clock begins to run when the buyer knows or reasonably should know of that cause of action. So in some cases, I could close escrow today, and it's a dry season in Phoenix, and 6 months from now, we get some heavy spring storms, and there's a massive roof leak. If the seller had knowledge of that roof leak and didn't disclose it, that 6-year clock should start to run from when the buyer discovers it. And so, it's not a hard cap at 6 years.
Yeah. Well, that's good to know.
And I'll say, too, that these things can be horrifically expensive. It's not uncommon for, take a lawsuit that actually goes to trial. You figure that buyer and seller are each spending well into the 6 figures on attorney's fees and experts just to get to trial. And so, and what's funny is the kind of the disparity between legal fees and the amount in controversy sometimes.
Yeah.
Sometimes you're talking about a $50,000 roof issue where each side could spend $150,000 litigating it. And had that been addressed properly, through disclosure, through potential negotiation on the BINSR, maybe it's a maybe the seller pays $20,000
on a seller
to get out from
credit.
under it,
Yeah, exactly.
right? And then instead they pay six figures in fees. That case drags on for 3-4 years plus before even talking about appellate issues. It's always worth it to make the disclosure. Always worth it.
In that scenario, does the winning side get reimbursed for their legal fees if the person has money?
So in Arizona, if it's a contract-based lawsuit, the prevailing party is entitled to recover a reasonable amount of their attorney's fees. But a lot of judges in Maricopa County will look at the amount in controversy. And number one, you don't find out about a fee award until the very, very end of a case, after a jury trial. So you don't know up front how much of your fees you're going to recover. But a lot of judges will say, this was a $50,000 dispute at most. You spent $150,000 litigating it. That is unreasonable. I think a reasonable amount of the fees is the amount in controversy. So I don't care that you paid $150,000. I'm going to award you $50,000.
I didn't know they could do that.
Absolutely. And so you could still find yourself in the hole, even if you're the prevailing party. I mean, the net outcome to you can still be poor. And setting aside the fact that, as attorneys, we deal with lawsuits all the time, right? But for a lot of people, going through a protracted lawsuit is probably the worst experience of their lives. Setting aside, the monetary cost, it's just a big drain on, and it just hangs over them.
Mm-hmm.
Oh, for sure.
Yeah.
In our limited experience with that class action, I could attest to that.
Right.
There's a few sleepless nights. Yeah.
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 I
You
could
just
imagine.
kind of felt violated. You felt upset. And then you're like, why are they grouping me in with this person in this scenario?
Yeah.
Like, just a totally different world.
I mean, that was a little over 2 years. Could you imagine if that was still going on?
No.
Well, thankfully, it's
Would have mentally set that aside after about 6 months.
yeah.
All right. So do you have any other scary
I've got a quick one, and this
to
was
make
actually
like the realtors just kind of perk up in their chair a little bit?
Yeah, this was actually one of the first cases I worked on as a young associate. Just a bizarre fact pattern that probably won't repeat itself, but it was a house. It was on the west side. The husband and wife were going through, as I understand it, a pretty nasty divorce. The wife had moved out. She was living in Vegas. On the morning of close of escrow, listing agent goes to the property. Both the husband and wife had already signed, so she's going there just to make sure everything's good and hand over the keys. She comes into the property, finds out that the night before, husband had shot himself in the head with a .22 caliber handgun.
That's not an instant death.
It's not an instant death. And so he ended up walking around in a bathrobe for presumably the next few hours, long enough to bleed everywhere on the white carpet. This is the scene that the listing agent walks into. And so she calls the buyer's agent and says, we've had an issue. We're going to have to delay closing by a couple days. So she scrambles to obviously call 911, and then she has all the carpets replaced. Meanwhile, buyer has no knowledge of what happened. So buyers close a couple days later. And then perhaps not surprisingly, they're informed by neighbors a month or two later that, hey, are you aware of what happened in your house? And of course they weren't. And it wasn't just that issue. Turns out that prior to moving to Las Vegas, the wife had used the property for shooting adult videos.
It's a nice little bonus.
Nice little bonus. How they found that out, I don't know.
Nobody fessed up on that one.
Nobody fessed up. It did make for an interesting disclosure because the video is actually part of the file in the lawsuit in terms of the disclosure. And so that raised a lot of issues about disclosure obligations and frankly damages. How do you quantify that? And in that case, interesting enough, the plaintiffs that brought the claim had an appraisal expert that actually came out and provided an expert opinion as to the diminution of value of the property as to both issues. That the undisclosed suicide devalued the property by X amount percent, and the undisclosed adult video shoot also devalued the property by some percentage.
Well, I think it depends on the buyer and what websites they subscribe.
That's right. But the suicide, at least, that was easily defensible.
Yeah.
At least from the suicide. Arizona has a stigmatized property statute that says you cannot be liable if you fail to disclose certain things. One of those is that if there's a suicide of the property.
Yep.
Again, it gets back to kind of like the sober living facility. You can't be liable for not disclosing it in terms of the suicide. Mm-hmm. But you have to be very, very, very careful if you're asked. And so that was part of the issue in that case was, when the agent had the carpets removed, was she being deceptive? And that was one of the issues we had to litigate.
Yeah.
What did they side?
They settled.
They settled. Okay. Yeah.
And so that's the thing is, but I'll say too that, that's the kind of case that it's so fact specific, it would be difficult to handicap. And you could present that to a jury and the jury may side with the buyer in one case and a different jury may say, no, we side with the seller.
So we were talking earlier about, not on the podcast, before we started recording, about the guy that got stabbed in his front yard, died, this and that, family selling the house, murder in the front yard. Clearly all the neighbors saw it. Us as the real estate agent, we actually had a broker open down the street. It was an interesting one. Luckily it was around Halloween. But what's the disclosure on that?
So this is different than the fair housing, right? Fair housing, you can't. Fair housing
that's a murder.
The statute's different. It says you can't be liable for failing to disclose it. So it's a decision. But fair housing provides certain protections against affirmative disclosure. Under Arizona statute, you can disclose it. And in some cases,
but you're
that
not
might
obligated
be,
to.
but not obligated to.
Yeah.
So that's the discussion you have to have with your seller, which is we don't have to tell anybody this happened. They're likely to find out. And we have to be careful if we're asked during the escrow period.
Yep.
And in some cases, you may decide, and the listing agent and the seller may decide, they're going to find out about this anyways. Let's get out in front of that and let's tell them now.
Yeah. Yeah, because we had that one where it came up as very interesting because seller doesn't have an obligation to disclose. Essentially, I think it was like a child inherited parent's house. Parent died in the property. It was a second home, lock and leave situation. They were there for a few days before they were discovered by a wellness check. And the insurance company paid out for remediation and had to redo the flooring and hazmat and all that stuff. And so while it wasn't disclosed on the SPUDs, because it doesn't have to be, we have to provide the insurance claim history report, and the insurance company listed it, I believe, as other peril. And so the buyer and the buyer's agent were like, what is this other peril? And I believe the seller in that case said, let's just get out in front of it. And I think you and I talked about that one. It's like they can if they want to, they're just not obligated to.
Right.
So, with RETSY, we arm our agents with some really good tools to discover everything they possibly can. And one that we just licensed, where every home they list, they get a full seller report from Real Reports. That's the Carfaxer home that we talked about. They added a section there that says like news and online, where they search the address against online databases. And we did have I actually pulled a seller report for a potential buyer that was looking at a property in the Cactus Corridor, and it actually stated the address and there was a fire at the house. But you look at the listing and it's like a brand new build. So it's like you have to use common sense and disclosure, but it goes back to ring alarms, neighbors, people, you have to disclose. It's out there. But now we're getting better and better tools. And I also think with AI kicking in, it's going to be really hard for people to hide stuff.
Well, and not only all those things, but sometimes sellers kind of, can you share the social media post?
Yeah, you can't hide. You can't hide from your past. In some cases, it may be all cases. We see these cases from time to. We see scorpion cases from time to time.
Yeah,
where buyer closes escrow, oftentimes in the winter. Right, scorpions aren't out.
They need more lines on the scorpion disclosure, the seller property disclosure statements. How many by when, how many per month, what months?
Yeah, that's a good point, because for those that aren't aware, on the seller property disclosure statement, there would be a box to check, for scorpions. Mm-hmm. This isn't are you pregnant or not pregnant? I think there's a material difference between I've lived here for 10 years and I've seen 2 scorpions versus some properties, you could go out and kill 20 scorpions a night in a backyard in the summer.
Yeah.
So yeah, good point. And I think the answer is, if you've got a significant scorpion problem, don't just check the box, right?
Yeah.
Provide some explanation.
For sure.
So, and one thing I learned from a builder friend of mine, and now they do this whole treatment on, the cedarwood shake roofs are so popular in my neighborhood, right? And where they store them, they just get infested with scorpions. So somebody can have no scorpions at a property, build a new construction home, put a cedarwood shake on it, and then all of a sudden that house has scorpions for a year, and the neighbors also get it because they come from the bundles. And I remember him telling me, he's like, one time I just dissected this bundle, or what did he? He's like, I put it in gasoline, and I dissected this bundle, and I counted like 40 scorpions. And you got to remember, there's hundreds of these bundles on these houses. What's weird is we just did our audition with cedarwood shake, and I'm like, make sure that there is no scorpions in that. But
let's treat this
that's
heavily.
A disclosure. Well, you guys are talking about social media.
So in our case, buyer closes escrow in the winter.
Okay.
Scorpions are difficult to find in the winter.
Yeah.
Come the
They go
summer, 6
dormant.
months later, they find a significant scorpion infestation at the property that was not disclosed. And we talked about, is it sufficient sometimes to check the box, or you should do more? The box wasn't checked in this case.
Oh.
So buyer does their post-closing due diligence, finds the seller's Facebook page, and the seller is bragging on Facebook about how many scorpions he had killed.
With the black light. And
So there's photos on Facebook of seller, lighting up a scorpion with a black light and his, sandal off ready to smush it.
Guilty.
Yep.
Did I ever tell the story of the lady over there by the PV Police Department? We had a closing on Malcolm. I don't know if you had to get involved or I just handled this one, but long story short, we had a listing, over in PV, needed some remodel and all that stuff. And we had somebody who she thought she was kind of an influencer, I would say. And it was like 3 days before closing, she goes over to the house, recording herself with a black marker saying, oh, I'm going to flip this home and make millions and this and that and follow me through, and black marker on all the marble countertops, on the cabinets, demo, this, just black marker all over the house, right? Just physically destroyed it. And then I can't remember what exactly happened, but like the day before closing, she's like trying to send over a loan denial letter. And I talked to the lender and I'm like, what's going on here? He's like, she says she can't find the funding and we're going to have to do a loan denial. And I'm like, dude, she literally went through this entire house with a black marker. And actually the lender's like, then I'd call the cops. So we did. We called the PV Police Department. And they're like, do you know who did it? I'm like, yep. He's like, can you prove it? I'm like, yep. He's like, how? I pull up her social media reel and he's like, okay. Calls her up. The irony is that deal did close 2 days late, but it closed. So.
Yeah. What was funny is when you told me that story, I immediately I remember posting on my social media about a slab leak I had in my house, going through that demo and repair. I'm like, yep.
You disclosed it, though.
I'm going to want to disclose this.
Yeah. I haven't sold that house yet, but I absolutely will disclose it. Lindsay, if you're listening, make sure I disclose that.
No, I mean, it's just we're in a day and age where people are litigious and they post everything online. So
Yep.
just be present. You should God, if you could have listened to the call when she called me, she was so pissed. She's like, I feel like I'm being extorted. I'm like, no, it's really simple. Like, you can close on the house or you can go to jail.
Or we'll press charges.
No, we were pressing charges.
Yeah.
Like, yeah. I mean, I called the seller. He's like, yeah. And not only that, but I guess it was over a certain dollar amount, which I think was $10,000 in damages. I mean, just the cabinets alone are $40,000.
Yeah.
So, I mean, yeah, the officer basically told her, like, unless this is your house, you're going to jail. Changed the whole tone of the situation. I remember my seller being so happy, and then that buyer definitely didn't want to give us the listing after she was done with the remodeling.
But we see that, right?
Yeah.
That, sometimes it's demo before closing.
Yeah.
We had a situation not long ago where
Yeah.
prior to the close of escrow, the buyer came in and started tearing things out.
Yeah.
You have to own the property before you take any adverse action against it.
Write that down.
Yeah.
Common sense is not that common.
Demo can wait, right? You need to close and have title before you
Yeah.
start ripping things out.
No, I think the more and more you see over the years, the more experience it brings to the table. That was kind of a first, but it's just, you see certain people get away with certain things, and it's kind of nice to actually have some sort of justice or justification. So,
No. Well, we're coming up on an hour, so
Yeah.
probably going to wrap up. And normally this would be the part of podcast where we'd say, how do people connect with you? But I don't want to do that. If you're a RETSY agent and you need to connect with Michael, let me know.
There you go. Fair.
I don't want to do that to you.
if you're hearing directly from Michael, you probably did something wrong. Can you share his website or? Yeah.
Whatever.
What do you feel comfortable sharing, if anything?
Yeah, so my firm is Jennings Howe Keller McLeod, jkwlawyers.com.
There we go.
And my contact information is on the site.
Yeah.
Perfect.
Amazing attorney. Thank you for all your help. And
Yeah,
you've
thank you,
also
guys.
been a lifelong friend. I mean, our wives were friends at CB before kids, and yeah, we've known each other for a really long
And
time.
I'm still waiting for the Alaska invite, Chris.
I didn't know you fly fish, but don't threaten me with a good time. Everybody knows,
Yeah.
I try to get at least 3 trips a year. But yes, we'll do that. I'll just pick your brain for legal advice and pay for the trip and just
There
call it
you go.
even.
Let's do it.
That's a good deal. That is a good
Matt's
deal.
I'm all about that.
Yeah.
But no, thank you for everything, all the support you give us. And you're just such a key part to the success story in RETSY. And we have agents at our company that have been on calls that you've been on that just have a level of respect for our brokerage and share that. So thank you for that. You're a big part of that.
I appreciate that. It's been fantastic working with both of you. And we should do this again. We've got some important topics we weren't able to get to that I think.
Maybe we'll have some people comment if they want version 2.0. Like you presented the G-rated cases, but can we get some R-rated?
Oh, for sure. No, we'll definitely do it again.
Great.
Thanks, Michael.
Yeah, thanks, guys.
Thank you.
That wraps up this week's episode of the RETSY podcast. Thanks for listening. Check out the show notes to connect with Michael. If you enjoyed today's episode, take a moment to leave us a review wherever you listen to this podcast. And please subscribe so you never miss what's next. Next week, Chris and Matt are sitting down with RETSY founding partner Libby Cohen. Here's a sneak preview.
They don't expect you to be perfect or that you're not going to, make mistakes. But what they do expect is for you to always to be there, to be consistent, and if something doesn't go right, to fix it, to find a way.
So if you stick around, there's bonus content. So let's start with this bonus content so we can keep that podcast around an hour. But it's very important what Michael's going to talk about. We're seeing it left and right. We saw it twice last week. Luckily, within RETSY, we have tools to sift out the fraudsters out there, the people that want to list fake properties that aren't the owners. They're doing deed fraud. There's just so many scams out there as agents that we have to protect our clients. Not only that, but I've used our tools to sift out people that are known for squatting in houses and have been arrested for it because of their criminal history that show up in the tool that we provide to all of our agents to protect them. But I know we had ended our podcast. And you're like, I really want to get into deed fraud. And I'm like, all right, let's do a little bonus section.
Let's do it. So there's two primary forms of deed fraud. One I'll focus on very briefly, and then we'll shift to what's probably more common here at least.
Yeah.
Where people actually forge a deed and record it.
Yeah.
The Arizona statutes in the law for recording a deed and transferring title is simply show up at the county recorder's office with a deed signed by the seller that's notarized. So it's really easy to do that. You can fake a notary stamp. I can fake a seller's signature. I record that deed purportedly from the seller into my name. As far as the county is concerned, I'm now the owner.
Yeah.
There's no identification requirements. Some states now have that. Arizona doesn't. And so if I took, to put a finer point on it, if I, created a deed, take about 10 minutes for your property, I sign your name, I forge it, I forge a notary stamp, I take it down to the county recorder's office and I pay the filing fee. As far as the county knows, that deed transfers title from you to me.
Yeah.
That's not the type of fraud that I want to talk about right now. What we're seeing more is when we have kind of the fake seller fraud, where what they'll do is they'll find usually a vacant property, not always. They'll do some basic research online to find out the owner's name, where they live. They'll call a listing agent working in that area and say, hey, I'm, Matthew Smith, I live in Canada. I own this property in Maricopa. It's vacant. My wife was just diagnosed with cancer. We were intending to build a house on it. Our plans have obviously changed. I need to sell it. I need to sell it quickly. I think it's worth about $300,000, but if you can get me a cash offer for $225,000, in the next week or two, I'll take it. So listing agent says, that's great. I haven't had many listings in a while. It all checks out. I will list it. We'll get an offer and we'll get it sold. What ends up, to play that transaction through, the title company would then, send a closing package to the, purported seller, and then they forge the deed at that point, right? Where they pretend to sign on behalf of the actual seller, and they either, pay a unscrupulous notary some amount of money, or they just forge the stamp, send it back, it gets recorded. And in some cases, the actual seller has no idea this is happening.
Yeah.
Title gets transferred. The fraudster gets the funds from the closing funds. And in some cases, that actual owner, seller, former owner, may not even discover this for, in some cases, years down the road. And I've had a number of people call me from out of state saying, I just found out that I supposedly no longer own this property. What the heck happened? And that's a fact pattern that we've seen happen time and time again. Some cases we see it be caught by agents midstream, and I want you to talk about that, Matthew.
Yeah.
In other cases, we find out about it after the fact, and title's gone, right? You no longer own the property, and you didn't get the proceeds of sale. But I think it's an underreported crime.
Yeah.
Because I think nobody knows the true scope of it, but we know that people are actively engaged in these schemes all the time.
Well, and I mean, so the fact that people could go years without noticing or knowing that they've been a victim. Yeah, I mean, like there could be a huge pool of victims that don't even know they're victims yet.
Well, I remember selling a $13 million house, and my client was in Boulder, and because it was an all-cash sale, I mean, basically they sent him the paperwork to bring into his bank to get notarized where he needed to sign. I mean, there wasn't even a notary involved. I mean, assuming he was a scammer, like he would have totally gotten away with it. Mm-hmm. It's just so, like, how do you get those checks and balances other than using common sense, using our forewarn tool to research the buyer, the seller? I mean, hopefully our agents are listening to this and using it more and more and more. I dissected that one we were talking about 2 or 3 days ago where the wholesaler's like clearly in on the scheme, but like his numbers, nothing shows up. Mm-hmm. It's like, well, if you're legit, give me your name, your phone number, your date of birth, or your real cell phone number, not the fake one you're using right now, so I know who you are. And he just wouldn't give it.
Yeah, and there are red flags in these situations. I hate to say it, but like almost any vacant land transaction right now, if the seller is not going to be signing in person at the title company with 2 forms of government identification, that's a red flag.
100%.
So if you're a listing agent and you're contacted by an out-of-state or out-of-country seller wanting to sell vacant land, that in and of itself is a red flag. You've got to
Would you guess like 90% of those are fakes, fraud right now?
They might be. We don't know. I think the NAR did a study recently. They asked how many agents had been involved in a scheme like this nationally, and I think it was like 63% of agents had dealt with it or were aware of it happening on some level.
Yeah.
So it's exceedingly widespread. And so, that's a red flag. Selling vacant land from an out-of-state or out-of-country seller, you've got to do your research.
Could an agent write in the contract and say that the seller must be present at title to sign in person? Could they force the seller to do that?
Potentially.
Just trying to think, how do we protect our agents?
So
how do we protect our
investigation
clients?
up front is good. One of the things you can do, well, and the reason why that's going to be problematic in some cases because, in Arizona, there are a lot of foreign owners of property. There's a lot of Canadians that own property. Not long ago during COVID, they had no ability to get to the United States, right? Mm-hmm. I mean, the border was closed. So if they needed to sell a property for legitimate reasons, that could not have occurred. They literally could not have come here to sign. But there are things that you can do as a listing agent. One of those things is do the background check on the purported seller. Do the research, find out who this person is. You can go to the county recorder or county assessor and get the mailing address for the actual owner. And granted, that's not always foolproof, but rather than sending everything electronically, you can send your listing agreement by mail to that known address for the seller, right? And of course, the fraudster is going to say, no, I'm traveling right now in London. Don't send it to my address in Canada. Well, that's a pretty big red flag. Then you say, okay, when are you going to be back?
Yeah.
Okay, it'll be waiting for you when you get back. Other things you can do are working with the title company. So if you think, even if you don't think there's a red flag, talk to the title company about how is the closing going to be facilitated. Is the title company just going to send a closing package wherever that purported seller is going to be and wait for it to come back? Or is that title company going to say, no, that's not how we operate. We are going to arrange for you to meet our notary or somebody that we've already vetted.
Yeah.
So for you to sign the deed, you have to go to this notary at this time and place, right? And we can do that virtually anywhere in the world.
Yep.
But we're not leaving it up to the seller to dictate what notary is used.
Yeah. Well, and that's been a red flag we've caught on some where the seller wanted to use a very specific title company. And I'm assuming they typically do like electronic signatures or, they want to use that title company for a very specific reason, I'm sure. But yeah, we've caught 5 or 6 of these before they ever got listed, just using the Forewarn app to, sniff out that we're not talking to the actual homeowner. And the very first one I remember, we were just testing that Forewarn tool. I had an account, and one of our agents called me on a property in Silverleaf and wanted some help and guidance on comps. And as I started looking at it, this was 2-3 years ago. And so this was, I had heard about it. I was aware of it. I had never seen one. And it just got red flag after red flag. We have vacant land. He's wanting to liquidate much cheaper than it's probably worth. And on that particular one, it had been listed by another agent 30 days prior for 5 or 6 days and then canceled. And so I asked our agent, I said, hey, I hate to burst your balloon here, but why did they list with so-and-so at so-and-so company and then cancel after 5 days? He's like, oh yeah, he said they just didn't see eye to eye and they had an disagreement and they canceled the listing. I said, call that agent and give me the phone number. When I ran the phone number, it came back to a completely different name, somebody with a long criminal record of like 27 different offenses that involved fraud and forgery and everything else. And by the time he called me back, I had got that report and sent it to him and said, hey, this is a scam. He's like, yeah, I talked to the agent. It was a scam. He was contacted by the homeowner or the property owner, which is actually the homeowner next door.
Well, it's funny you say see eye to eye because the listing agent and that purported seller did never see eye to eye in a literal sense. And that's one of the things agents can do also is have direct communication, at least through FaceTime.
Yeah.
You can demand to say, all right, I will list this. Send me your identification proving it that you're the seller, and we're going to have a FaceTime call.
Yeah, that's a good.
Even when you get them on the call, FaceTime call would be the deal. Like that would help pan it out. I was looking we have this program called RETSY Connect at RETSY. It's like our Facebook page, and we have different groups, and we share listings and pocket listings and ideas and different things between our agents. And one of the groups is called Scam Alert. So we just kind of post it so other ones don't fall for it. But I had a really good one that I was thinking of. So it was a year ago. Ironically, I was in Montana fly fishing when this guy called. I'm not going to use his name because people may know him. We're just going to call him Dominic M. But I actually knew the guy because he owned a company in town, and I knew of him. So when he texted me, I thought it was weird that I didn't have a text chain with him or anything. He's like, I want to list my house or my lot on Invergordon. I'm like, great. I get back from Montana. Let's meet in person. I'll take you out to lunch. He's like, I thought I told you I was on a business trip. And I'm like, that's kind of rude. And then all of a sudden I realized, I'm like, this is not him. So I called him and I realized it wasn't him. So then I decided to go through a process of effing with this guy for a couple days. So I made him get me a deed for the property, which he sent me, right? And then an Arizona driver's license. I'm like, I need a copy of your driver's license. If we're not doing this in person, I need your driver's license. The fact that this guy looks so creepy, but if you look at this driver's license, it's so real, but it's just kind of cut off on the corner. Like I made him go through all these steps, and then I eventually texted him like, I got to be honest with you, dude. I'm just messing with you. I know you're a total scammer, but thanks for the time and nice try. And then I called Dominic M. and I'm like, hey, let me send you a copy of a driver's license. And he's like, not only is this guy creepy looking, he's like, I'm living in a rental right now, and he has my rental address on my driver's license. So either he got a copy of the owner's driver's license and just superimposed his face on it in his picture, or like he did even more research. I'm kind of curious. We should pull this lot up and see which agent fell for it.
Well, and it's funny because none of this is funny, but how these schemes have morphed. Like, so when I first started practicing law, it was a rental scheme, right? Where it was,
God, I remember that.
It was, I'm the owner of this property. I just relocated for work to Africa.
Yeah.
I'm now renting it out. You can rent it for $3,000 a month. Send me your first and last month. Send us a check for $4,500, $6,000 to somewhere in Africa.
Yeah.
We have it happen all the time because you know how Kelly and I own our rentals. Well, every once in a while we get a call and be like, when do I get the keys? And it's like, for what? Like, for this property? I'm like, no, like, I don't even know what you're talking about. How'd you get my number? And they're like, well, we were texting somebody else in your family and we sent them a deposit for your house. And I'm like, sorry, you fell for a scam.
And the upside of that scam was a check for a couple grand, right? The upside here is title and the proceeds, right?
For $2.5 million.
We're seeing multi-million-dollar lots. And it's not just lots. Some people are now preying on, people that are winter residences here. And they may have, a property in North Scottsdale, a golf course community that they don't use for 6 months out of the year. And those can fall victim to this as well. But, so one of the questions is, in Dominic's case, okay, somebody's clearly targeted my vacant lot that's worth millions of dollars, and they're trying to, defraud me of title and sell it. How do I stop that? One of the things that the counties are all doing is they've created an alert system where if you sign up for an opt-in, if there's a change in title, they'll notify you. Well, guess what happens when there's a change of title?
It's too late.
It's in some cases too late, right?
Yeah.
I mean, I'd rather know about it a day after the fact than a year after the fact. But once they notify me, the transaction's closed escrow, and those funds have been dispersed.
Is that where your previous title insurance kicks in? And
potentially, I'd want to. Again, this is like the agency stuff we're talking about. You can avoid liability by making the disclosure. It's pretty simple. There's other things you can do here as an owner. And this can be an opportunity for agents. If you have a client that buys vacant land, you can say, hey, this is an issue with vacant lands in Arizona and probably every other state. You've closed, I've got my commission, you own this vacant land, but as a courtesy to you, I'll set up a notification where if any other agent on MLS lists your property, it'll ping you. Or it'll ping me and I'll call you. And that's a way of like keeping engagement with that client that may wait a few years to either sell or build. Notification is probably the best way to do it. My guess is you can do it. There's probably a lot of other platforms that you can get notification if it comes on the market. Yeah.
Can't somebody record like a lien against their own house for a certain dollar amount too? So like they would have to clear lien to change title?
Yeah, that's something you should talk to an attorney about on a case-by-case basis because you can. Sure.
He's doing so.
Michael,
yeah.
Did we just get billed for this hour?
There's ways that you can do it. The idea is to create a cloud on your own title.
Yeah.
And there's different ways to do it. You could record something that says, title company only allow my property to convey to a third-party buyer if I show up at your office in Maricopa County with two forms, personally appear with two forms of identification. There could be issues with that down the road. Let's say I do legitimately relocate out of the state and I can't come back for some reason. Have I just clouded my title to the point that I can't sell?
Yeah.
Or what if I die?
Yeah.
Yeah.
It's going to make it really tough for me to show up in their office in Maricopa County.
Yeah.
So there's pros and cons of that. In some cases, I think it can be advantageous to do it, but you've got to weigh some of the risks.
Yeah.
Yeah, I think we're going to see as this progresses, there will be companies out there. You remember like when the identity theft thing came along and then those guys came up with LifeLock, which all they really did was charge you to lock your insurance or your Experian, TransUnion, all your credit reporting agencies and charge a fee for it. There's got to be a way in Arizona to stop this.
Yeah, there already is a company that does. It's called Home Title Lock, I think, and they do monitoring and give like an insurance policy. It's a perfect example. It's basically a LifeLock for your home.
Sad that we need it, but I mean, honestly, we encountered it twice this week.
Yeah.
Did you tell the story of that?
Yeah, so I had told Michael about that. We saw a twist on it where instead of pretending to be the actual owner of the property, one of our agents was contacted by somebody with a wholesale contract and said, hey, I have a contract with the seller. I have equitable interest. I want to list this lot for $50,000, $75,000 more than I'm buying it from this seller from. And it didn't pass the smell test, and there was quite a few red flags on their wholesale contract that I pointed out. And the best part about that was when he
the
called.
Scammer called you?
No, when our agent called the scammer back and basically said, "Hey, I'm sorry, we can't take the listing," and we had a conversation with the owner and found out this is a scam, and he said, "Well, when they how they get connected with us is they fill out these online forms and they get all sorts of calls from all sorts of wholesalers. So we actually coach them to say the house isn't for sale." And so like just kind of trying to like manipulate it.
Right.
And he goes, yeah, and there's some other problems with your contract, but hey, good try. We're not going to take the listing. He's like, well, what red flags did you see?
He's like, help me perfect my craft of scamming people.
Well, we see they're diligent, right?
Yeah.
And in many cases, they're not getting caught. And so to your earlier point where it was the Silverleaf lot where the actual owner happened to live next door.
Yeah.
Somebody caught it just before your agent did,
Yeah,
right?
yeah.
And so you can get caught. You can say, all right, well, I'm not listing this because it's a scam.
Yeah.
They're just going to call another agent.
Yeah.
And they're going to keep going down the line until they can. We had a client, this has been a couple years ago, a brokerage client that caught one of these scams in midstream. So they had taken the listing. They probably didn't vet it appropriately because they actually listed it for a certain period of time.
Yeah.
And then the actual owner called the listing agent and said, what the hell are you doing? Like, I did not authorize you to list my property for sale. So, of course, then they figured out that they're working with a scammer. They immediately contact the AG's office, all the authorities, FBI, and then they make contact with an agent. And then so the listing agent thinks they can catch the guy, right? And so they maintain communication about, hey, we haven't had any offers recently. We'll let you know when we do. Email back and forth with the scammer. They're passing all that correspondence on to the FBI. After about 2 months of this, knowing that they can't actually close, they finally just give up and cancel the listing. And so that's the frustration is.
Could the FBI catch them? I mean, the
Right.
reality is, you have like partial economies in countries that are just designed around scamming U.S. people.
Yep. And a lot of these scammers are not based here.
And they're good. They're good
yeah.
at what they do. So,
Unfortunately.
yeah. As long as people keep falling for it, they got a reason to keep doing it. So
Yeah.
all we can do is just notify people, work with a reputable agent that knows the neighborhood, that has the tools to protect you, and seek legal advice when needed. And, honestly, I wish we had a better solution other than, maybe we can post a link to that title monitoring service.
Yeah, we can have Jack link that in the show notes.
This episode's sponsored by.
Yeah,
Just kidding.
exactly.
It is not
Let's
sponsored
negotiate that deal first.
Yeah.
by. Michael, you want in on that? No, but anything else you want to cover on that part? I know this is a little bit of a bonus section, so.
No, other than just to say that these things change. To Matthew's point, that wholesaler was a new wrinkle.
Yeah.
And I think the second wrinkle in that fact pattern also that you didn't talk about was that it was a referral from a legitimate agent in another jurisdiction.
Yep.
And so they try to create this like air of like, I'm a real estate investor, and that okay, that it's not just the typical I own this vacant lot and I want to sell it. It's no, I'm a real estate investor and I've got this thing under contract as a wholesale. I got to you from this agent I've worked with in Seattle, and that's how I got to you. And so they kind of create this plausible reality of, okay, this all adds up. Real estate investors do wholesale properties. And I vetted this other person, got the call first and said, yeah, he called me, I referred him to you. Okay, we're good to go.
Yeah.
So the point is that these things, they're not static. These things are fluid. They change. When they fail, they come up with a new scheme. And so you've got to be, what has caught people in the past doesn't necessarily catch them in the future.
Yeah.
Well, with AI and the way they can generate bank statements and pictures, or like that one guy I had a year ago that was fraud by adverse possession or whatever. I mean, he had called me. He had a Southern accent, spoke walk the walk, talk the talk. Like started with like, oh, I just got done with a fly fishing trip. I'm like, oh, where? And he's like, oh, in Alaska. Then he sends me photos of him holding fish in Alaska or him on his boat in Florida. Fully checks out, right? And I don't know why. Maybe we were just playing with the tool. I decided to check him on forewarn, and it was like criminal. Like basically, he would go to a house, move into it, and try to claim possession of it. I was just floored. Like this guy had me. Like, and my radar detector for like scams is always up when somebody calls me that I don't know. So.
Yeah. Well, I think the most practical tips for agents is you absolutely need to do your due diligence. If it's vacant land and you don't know the seller, like that's a red flag right away, and additional due diligence is needed. Use your forewarn tool. I think that's some of the best money we spend as a brokerage.
We'll report on every property, get all the background, the history.
100%.
The new ones even tell you who the seller is and their phone number. So.
Yep.
Yeah.
So cool.
Well, thanks, Michael.
Yeah, thank you.
Of course.
Good little bonus section.
Yeah.
But I'm glad you brought it up, and I'm glad we put it out there on the table because like buyers, sellers, agents, wholesalers, they all need to know this.
Well, I think it's important for owners to know too. I mean, I think a lot of real estate professionals are now aware of it.
Yeah.
It's been a common talking point in the industry for the last few years, but I think there's a lot of owners that,
It doesn't
and
make
that's
the
part of the
news.
nature of like vacant property. I bought a vacant property in some rural part of Arizona with an intention to build in retirement, and I might just kind of let it sit there for 20 years, right?
Yeah.
And forget about it. And those types of people aren't necessarily tuned to what's going on the ground level. And so, in one of the cases where I had a client call, it was probably about 2 years ago, they had just found out that they lived in New Jersey, owned 6 vacant properties here. They found out that one had been stolen through deed fraud. And so then the obvious question is, after figuring out how do I get my money back on the first one, is what do I do about the other 5?
Yeah.
And notification after the fact isn't necessarily
Helpful.
prevention.
Yeah.
Yeah.
No, it is not.
All right. Well, thank you so much
Yeah, of
again for your
course.
time. And
Yeah.
we'll definitely, I'm sure we'll have some questions, comments. We'll have to have you back. So
Yep.
Yeah, I look forward to
be
it.
careful. We'll make this a monthly thing.
It's been
Michael.
fun. Thanks, guys.
Thank you.
Appreciate it.